कुछ खूबसूरत हरे भरे पहाड़ों की गोद में बैठा दिखता है लाचेन, जहां एक छोटे से इलाके में इकट्ठा है कई सारे घर, जिसमें हर घर की छत पर ये बड़े बड़े प्रेयर फ्लैग्स लहराते दिखते हैं। लाचेन में अभी गर्मियां चल रही हैं और गर्मियों में अभी इस टाइम पे सुबह के -2 डिग्री टेम्परेचर हो रहा है और मेरे पूरे हाथ जम रहे हैं, पूरे पैर जम रहे हैं। बहुत ज्यादा ठंडा है। सामने आपको खूबसूरत सी पीक दिख रही होगी, गोल्डन हो रखी है, जो अभी मतलब सनराइज के टाइम पे बहुत ही खूबसूरत है। लाचेन के हर नजारे में झलकता ये बर्फ से ढका पहाड़ है लामो अंगदम, जिसकी हाइट लगभग 20,000 फीट
WWF मार्फतबाटै चाहिँ गरेर घरद्वार हरेक चिज यहीँबाट मैले गरिरहेको छु। नानी पनि यसैबाट पढाएको र मेरो फ्यामिली सबैलाई नै यसैबाट गरिरहेको छु, WWF गरेको छु।
हामीले यो चटकपुर रेलवे साइडिनमा यो हामीले नर्सरी सुरु गरेर आउँदाखेरि धेरै कठिनहरू हामीले भोग्नु पर्यो। त्यसमा हामीलाई WWFबाट चाहिँ अब सिसाहरू दिएर हामीलाई एउटा बेड बनाउने सिसाहरू
I request the eminent delegates of this august gathering to kindly be seated as the Honorable Chief Justice of India has arrived at the venue. Ladies and gentlemen, the Honorable Chief Guest and the esteemed dignitaries are on their way to the dais. Good morning and a warm welcome to the Honorable Chief Guest, Honorable Mr. Justice Suryakant, Chief Justice of India, and our distinguished dignitaries in this august gathering. Honorable Lordships and my distinguished guests, we are gathered here today for a conclave organized by the Honorable High Court of Sikkim and the Sikkim Judicial Academy. The theme of the conclave is Technology and Judicial Education. Additionally, the Honorable Chief Guest shall also officially declare Sikkim as the first paperless state judiciary. This gathering of distinguished judges, legal luminaries, academicians, and technology experts will proceed to deliberate on the evolving role of technology in strengthening judicial systems and enhancing legal education. The conclave will comprise of two conferences held simultaneously. Conference 1 at the present venue will be on the theme of technology for transformation of Indian judiciary, and Conference 2 shall be held at Samman Bhavan and on the theme Commonwealth Judicial Educators in the Digital Age. The conference also has a sign language interpretation support from Mr. Vishal Biswakarma, Indian Sign Language Interpreter from Composite Regional Center for Skill Development, Rehabilitation, and Empowerment of Persons with Disabilities, Sikkim. I now humbly request the kind permission of the Honorable Chief Guest to commence with the program. We will now present traditional khadas to our esteemed dignitaries. In Sikkimese culture, the khada is presented as a mark of respect towards the esteemed dignitaries and also as a sign of warm welcome. I now humbly request Honorable Mr. Justice A. Muhammad Mustaq, Chief Justice, High Court of Sikkim, to kindly offer the traditional khadas to our Chief Guest, Honorable Mr. Justice Suryakant, Chief Justice of India. Thank you, Lordship. I now humbly request Honorable Mrs. Justice Meenakshi Madan Rai, Judge, High Court of Sikkim, to kindly offer the traditional khadas to Honorable Mr. Justice Mr. J.K. Maheshwari, Judge, Supreme Court of India. Thank you, Ladyship. I humbly request Honorable Mr. Justice Bhaskar Raj Pradhan to kindly offer the traditional khadas to Honorable Mr. Justice Roni James Govindan, Chief Justice of Supreme Court of Seychelles. Thank you, Lordship. I request the learned Registrar General, High Court of Sikkim, Karma Wangchuk Sir, to offer the traditional khada to Honorable Chief Minister of Sikkim, Shri Prem Singh Tamang Sir. Respected R. Venkataramani Sir, learned Attorney General of India. Mr. Basava Prabhu Patil Sir, learned Advocate General of Sikkim. Senior Advocate Tashi Rabdan Barfungpa Sir, President Bar Association of Sikkim. Respected Madam Dr. Doma T. Bhutia, President, Sikkim High Court Bar Association. Thank you, learned Registrar General, sir. May I now humbly request all present here to rise for the national song. Honorable Chief Guest, sir, and our distinguished dignitaries. We will now have the learned members of the Bar Association of Sikkim present a song titled Zahan Bakcha Tista Rangit, which unites the Sikkimese people with the immense sentimental value it holds. The song is a soulful tribute to Sikkim, where the sacred Tista and Rangit rivers flow, and Mount Kanchenjunga stands as a guardian deity for Sikkim and the people. Thank you to the learned members of the Bar Association of Sikkim for the heartwarming rendition of their version of Jahan Bakja Tista Range. I now humbly request Mr. Justice Bhaskar Raj Pradhan, Judge, High Court of Sikkim, and Chairman, Computer Committee, High Court of Sikkim and Sikkim Judicial Academy, to kindly begin this national conclave with his opening remarks.
Good morning, everybody. Honorable the Chief Justice of India, Mr. Justice Suryakant, the Honorable Chief Minister of Sikkim, Shri P.S. Gole, Mr. Justice J.K. Maheshwari, Judge, Supreme Court of India, Mr. Justice Roni James Govindan, Chief Justice, Supreme Court of Seychelles, Honorable Judges of the Supreme Court of India, Justice A. Mohammad Mustaq, Chief Justice of the High Court of Sikkim, Shri R. Venkataramani, the Attorney General for India, Honorable Chief Justices of various High Courts of our country, Justice Meenakshi Madan Rai, High Court of Sikkim, Honorable Judges in charge of the computer committees and judicial academies from across the country, the Advocate General of Sikkim, and the Presidents of the Bar Association of Sikkim. The two-day national conference organized by the High Court of Sikkim commences today. The first conference will explore the use of technology for transformation of the Indian judiciary. The second conference relates to judicial academies. We shall explore the ways and means to create a platform for Commonwealth judicial educators to exchange best practices in digital judicial education. To guide us on this way forward, we have before us in the inaugural session, the Honorable Chief Justice of India himself. We also have the finest judges, jurists, and legal thinkers from the Supreme Court of India, Chief Justices, and judges of various high courts, judges of the Supreme Court of Sri Lanka, domain experts, and academicians, members of the Commonwealth Legal Education Association, and the National Judicial Academy deliberating these 2 days. When I see this hall filled with the finest legal intellectuals from every corner of India and abroad, it gives me immense pride to think that Sikkim has also entered the national legal mainstream. I take this opportunity to welcome all of you to Sikkim. We have come a long way since inventor Blaise Pascal built the first mechanical calculator in the year 1642. It was way back in the year 1955 that the term artificial intelligence was coined at the Dartmouth Summer Research Project. Today, artificial superintelligence surpasses human intelligence, almost eclipsing biological intelligence. What we notice is two conflicting thoughts, one skeptical, the other progressive, that accepts the inevitable but chooses a reasoned and informed approach. We cannot shy away from technology or the inclusion of artificial intelligence in almost every aspect of our lives. The success of eCourt's Mission Mode project launched in 2005 and the effective use of virtual court system during the COVID-19 pandemic has enthused the Indian judiciary to explore further. Today, artificial intelligence is everything that I want it to be. It is more intelligent, more smarter, more resourceful, and more informed. While use of artificial intelligence for administrative purposes like causeless management, case clustering, translation, transcription, research assistance, scheduling, and registry scrutiny has become a necessity. The temptation to use artificial intelligence tools to script well crafted judgments cannot be ignored. We must be collectively certain that the bench must remain a space for human conscience and wisdom. Therefore, regulation of artificial intelligence is imperative. A national conference of this nature to explore the use of technology for transformation of the Indian judiciary must also have a national goal. Universal digital access to justice, mandatory and fair e-filing rollout, paperless courts, integration of artificial intelligence without allowing it to transgress the humane element of justice dispensation, judicial data governance framework, pendency reduction, and interoperability across institutions are some of the things that come to mind. The Commonwealth Judicial Education Conclave must set its goal for digital competency for every judge. Modern judicial pedagogy, ethics curriculum for artificial intelligence in court, and restructuring judicial education scientifically with the help of technology is the need of the hour. To effectively harness the technological and artificial intelligence advancement for imparting judicial education scientifically, guided by a collective judicial conscience, should be our goal. How can you use technology to train our judges is not the only question we should explore. We should also explore the possibility of using technology to equip our trainers to better impart judicial education. Judicial education must be reconceived. It is no longer sufficient to teach the law. A judge today must understand how these systems are built, where they are prone to error, and perhaps most critically, when to set them aside entirely. We are training them to remain judges in a world that will increasingly hand them tools designed to do their thinking for them. What we should not lose sight of is our constitutional vision and mandates. Technology must strengthen the rule of law, and every reform should be tested against Article 14 fairness, Article 21 due process, open justice, reasoned decisions, and equality before the law. The core of the process of technological advancement and artificial intelligence competence should be to preserve human dignity and uphold our constitution. The economic disparity of our nation should not allow litigants to lose their rights and be digitally excluded. With approximately 70% of the Indian lacking reliable connectivity and only 30% of the household digitally literate, we must be cautious and conscious that our ventures into technological and digital advancement should not further distance the marginalized groups. If you use technology to make courts faster, fairer, cheaper, more accessible, and more humane, we are bound to succeed. The measures of our judicial institutions has never been the volume of its output, but on the public confidence that the disputes are resolved by impartial human judgment according to law with fairness and dignity. If technology helps us to fulfill this mission, we must welcome it. If it seeks to dilute, we must restrain it. I think this would be an opportune moment for us to formulate a Gangtok Declaration 2026, which would include the national roadmap of the use of technology, artificial intelligence, ethics and charter for the Indian judiciary, model cybersecurity standards, training framework for judges, timeline for paperless courts, inclusion plan for remote and poor litigants, and at last, an annual review mechanism. I'm overwhelmed by all your presence. Thank you so much.
Thank you, Lordship, for your enlightening opening remarks. Ladies and gentlemen, permit me now to share with this august gathering a short video presenting Honorable High Court of Sikkim's journey to establishing India's first paperless state judiciary.
For decades, the justice delivery system has relied on physical records, files, documents, and massive bundles that carried the weight of every single case. But as the volume of cases grew, managing these records became increasingly complex, straining speed, accessibility, and overall efficiency. The introduction of the e-courts e-filing marked the first major step towards a digital transformation. This allowed advocates to transition from physical filing to the electronic submission of cases. This transformation is guided by the vision of the Honorable Chief Justice, High Court of Sikkim, along with the unwavering guidance and support of the Honorable Judges of the High Court, moving beyond simple adoption towards innovation. The Sikkim Integrated Case Management, Sikkim, was developed tailored specifically to the specific needs of the court, providing greater flexibility, improved control, and the ability to evolve with changing requirements. Advocate Dashboard, offering real-time insights into case filings, scrutiny status, defects, and upcoming hearings, all in one place. Advocates can easily select the appropriate case types through a guided and a structured interface. Sikkim enables advocates to securely upload and manage all case documents. After review by the advocate, the filings are finalized. The AI system then automatically generates the index. Subsequently, the advocate submits the e-filing brief. Scrutiny officers review the case for any defects. If any are found, the case must be resubmitted. Advocate resubmits after curing defects and the case is registered. The case then moves to the reader of the court, who prepares a summary for the honorable judges and forwards the case for listing. The listing officer then creates a cause list digitally. Judges are offered easy interface and dashboards for the courtroom with advanced features. District Sikkim Integrated Case Management (DSICM) represents a transformative leap in Sikkim's judicial infrastructure, centralizing court operations into a unified digital ecosystem. The Advocate Dashboard centralizes case life cycles, providing real-time tracking of filing, pending actions, and personal schedules. The e-filing module digitizes the entry of new cases and applications, eliminating physical paperwork and reducing filing time. This feature automates the serving of copies to opposing parties, ensuring legal protocols are met with verifiable digital records. Real-time causeless provides immediate updates on courtroom activity, helping legal professionals manage their time across multiple hearings. Judicial dashboard provide judges with visual analytics on case pendency and age, assisting in the strategic disposal of long-standing matters. Integrated AI tools and annotation features allow for instant summarization of case files. Advanced AI voice-to-text capabilities streamline courtroom documentation by converting spoken proceedings into accurate searchable text in real time. The personal note feature provides judges with a private, digital space to organize thoughts, highlight key evidence, and prepare for upcoming judgments. The Civil Process Module digitizes the issuance and tracking of summons and warrants, bringing greater accountability to the execution of court orders. Every transformation begins with a vision, and every vision takes shape through dedication, effort, and persistence. The journey towards digital transformation at the High Court of Sikkim has been one of continuous learning and progress. From managing physical records to taking giant leaps towards digital systems.
May I now invite respected Basaba Prabhu Patil, sir, Learned Advocate General of Sikkim, to kindly address this August gathering.
Honorable Justice Suryakant, the Chief Justice of India, Honorable Chief Minister of Sikkim, Shri P.S. Tamang, Honorable Justice Ronnie James Govindan, Chief Justice, Supreme Court of Seychelles, Honorable Justice J.K. Maheshwari, Honorable Judges of the Supreme Court of India, Shri R. Venkatramani, Learned Attorney General for India, Honorable Mr. Justice Muhammad Mushtaq, Chief Justice, High Court of Sikkim, Honorable Judges of High Court of Sikkim and other High Courts, distinguished judicial officers, members of the bar, academicians, technology experts, officers of the registry, ladies and gentlemen. A very good afternoon to all of you and a very warm welcome to slightly cold Gangtok and to the National Conclave on Technology and Judicial Education. It's a privilege for me as the Advocate General of State of Sikkim to stand before this August gathering at a moment which is both institutional and historic. We meet today not merely to inaugurate a conference, but to mark a transition from files to platforms, from paper movement to process movement, from the idea of computerization to the deeper idea of truly accessible, efficient, and citizen-centric judiciary. Sikkim is a small state on geographical map, but today it makes a large statement for justice delivery system of India. In a land known for its mountains, monasteries, and ecological consciousness, it's fitting that judiciary should also take a step that is modern, disciplined, and green. Every file not printed is, in its own small way, a bow to the Himalayas. This is a proud day for Sikkim. It's also a meaningful day for Indian judicial system. Our small Himalayan state is today making a large statement that the future of justice need not wait for scale. It can begin with clarity, conviction, and cooperation. The point of paperless judiciary is not to disrespect paper. Paper has carried our pleadings, precedents, evidence, and constitutional history. The point is to ensure that citizen does not have to wait because a file is in transit, a page is missing, a record is untraceable, or a certified copy is moving at the speed of dust. Technology at its best is not about replacing justice. It's about removing frictions from justice. In that sense, today's declaration is not just about becoming paperless, it's about becoming faster, cleaner in process, more transparent in moment, and more prepared for the future. The High Court of Sikkim and Sikkim Judicial Academy deserves our warmest congratulations for bringing together two conversations that are now inseparable: the transformation of courts through technology and the training of judges, lawyers, and court institutions for digital age. The program itself reflects that this dual purpose: one conference on technology for transformation of Indian judiciary and another on Commonwealth judicial educators in digital age. We are particularly privileged that the declaration is being made in the gracious presence of the Honorable Chief Justice of India, Justice Surya Kant. Sir, your Lordship's leadership comes at a time when judicial technology is no longer viewed as a mere accessory to justice, but as an integral part of its working architecture. From inaugurating the first fully paperless district judiciary at Wayanad to describing such initiatives as steps that democratize the access to justice, your Lordship has given this movement both direction and urgency. At the same time, your Lordship's recent caution against AI generated fake citation is an important reminder that the future of the courts must be digital but never careless, innovative but always verified. And only a day ago, while launching the SCBA digital portal, your Lordship's observation that nothing is done in his court unless the bar really wants it captures the central principle of any lasting reform: that the bench, the bar, and the registry must move together. In that sense, Sikkim's declaration as a paperless judiciary is not an isolated milestone, but part of larger national movement that is practical, participative, responsible, and full of promise. In fact, what Sikkim is doing today is not an isolated local experiment. It's part of national movement. And if I may say so, Sikkim is embracing that movement with characteristic discipline and grace. This initiative also bears the imprint and vision of Honorable Justice Muhammad Mushtaq, Chief Justice of High Court of Sikkim. His Lordship brings to this subject not only judicial experience, but a rare understanding of law, technology, and institutional reform. His Lordship's own profile records specialized study in space and telecommunication law, and his long association with court computerization, including as chairman of Computerization Committee of the High Court of Kerala, gives this initiative both intellectual depth and practical direction. It's also significant that Justice Mushtaq recently spoke on the need for continuous judicial process for re-engineering enhanced e-awareness and robust framework for electronic records and registers. That, to my mind, captures the heart of the matter. A paperless judiciary cannot be created merely by scanning papers. It requires rethinking the process itself. Otherwise, we would only be converting yesterday's inefficiencies into today's PDFs. And here, I must also commend the support and vision of the Honorable Chief Minister of Sikkim, Shri P.S. Tamang. The government of Sikkim has, under his leadership, repeatedly emphasized citizen-centric governance. The launch of Connect to CM platform was described as an effort to bring governance to the doorsteps of the people and to enable citizens to directly raise concerns and access public services. Similarly, the launch of Soreng's citizen-centric e-services was aimed at paperless, hassle-free governance and reducing the need for citizens to physically visit government offices. That's why today's judicial initiative fits naturally into the wider story of Sikkim. When the executive speaks the language of citizen-centric digital governance and judiciary speaks the language of paperless, accessible justice, the beneficiary is ultimately the same person, the ordinary citizen. Judges, lawyers, court staff, registry officials, and litigants must all be part of this transition. A paperless judiciary cannot become a peopleless judiciary. It must be humane, accessible, and inclusive. For a state like Sikkim, this is especially important. Our geography teaches us distance is not merely measured in kilometers, it's measured in weather, roads, connectivity, and time. If technology can make justice more accessible to a citizen in Mangan, Namchi, Pakyong, or Soreng, then technology has served the constitution. If a young lawyer from a district bar can access records without procedural intimidation, technology has served the bar. If a judge can retrieve the correct pleadings instantly and focus more deeply on the legal issue, technology has served adjudication. But the success of this transition will depend on three things. First, simplicity. Technology must be user friendly. If e filing becomes more difficult than physical filing, we would only have replaced one queue with another and given it a password. Second, training. Judicial education is central to transformation. Judges, lawyers, registry staff, and court personnel must all be made comfortable with the system. A digital court cannot be sustained by software alone. It must be sustained by trained human beings. Third, trust. This system must be secure, reliable, and predictable. Lawyers and litigants must know what is filed will be received, what is uploaded will be preserved, and what is listed will be accessible. That is why the presence of judicial adjudicators, technology experts, and Commonwealth participants gives this conclave special value. The issues we discussed today of digital records, virtual court management, blockchain, artificial intelligence, e-filing, judicial training, and cross-border learning are not distant academic themes. They are working vocabulary of the court system that's already arriving. Sikkim, therefore, is not merely declaring itself paperless. It's declaring itself ready to participate in the national judicial transformation, ready to become a model for smaller jurisdictions, ready to show that agility can be as powerful as size, ready to demonstrate that technology, when guided by judicial wisdom, can make institutions stronger and citizens more confident. I congratulate the High Court of Sikkim, the Sikkim Judicial Academy, the E-Committee of the Supreme Court of India, the state government, the registry, the computer committee, the technical team, and every officer and staff member whose work has made this day possible. Declarations are made from the dais, but transformations are built quietly in server rooms, filing counters, training sessions, late evening meetings, and by the people whose names may not appear on the program schedule. May this conclave, therefore, not remain only a celebration of what has been achieved, but become a working roadmap for what lies ahead. Sikkim's journey as a paperless judiciary must show that technology can make court not only faster, but also more accessible, not only more efficient, but also more humane, not only more modern, but also more faithful to the constitutional promise of justice. And perhaps in the years to come, when a young lawyer in Sikkim asks what a paper book once looked like, we may smile and say, it was heavy, it was sacred, it was often misplaced, and thankfully it helped us to reach here. With that hope and with great pride in this important initiative, I once again welcome all the dignitaries and participants to this conclave and wish the deliberation every success. Jai Hind.
Thank you, sir, for your valuable remarks. It is my proud privilege to invite Mr. Justice A. Mohammed Mustaq, Chief Justice, High Court of Sikkim, to kindly deliver the presidential address.
Very good afternoon to all. It is indeed an historic moment for the state of Sikkim, and also an historic moment for the Indian judiciary. We're all assembled here in the presence of Honorable Chief Justice for brainstorming and discussion, deliberations for transformation of Indian judiciary through IT initiatives. Last 21 years we're working on it. Perhaps the one country we can boast is India. We initiated the earliest initiative in building IT infrastructure. But sad part of that, we have not reached anywhere. We are struggling still with the digitization. Forget about digitalization. Today's conclave is all about start something at the ground level with a practical approach. The paperless judiciary here is not our hand, but digitalization is hand. We need to transform Indian judiciary. The government willing to fund for us, but we are not willing to take initiative forward for whatever the reasons we faced. So today's conclave is all about having a practical approach. For start with it, we have a huge problem with huge workload in every aspect, especially our trial courts. What we could do in Kerala, it's a greatest example. We were able to establish 2 courts. It's a collateral impact of digital initiative because we were able to generate surplus human labors, human resources, and we were able to start 2 courts in Kollam district. So this is how we make the difference. It's not make our idea is to have a fashion or a high-tech coach, but rather to impact upon the life of ordinary citizen. So today's conclave is all about that. The 2 conferences, one is upon technology and the other about judicial educators in digital age with collaboration of Commonwealth, is all about to make those differences in our life, and those make the difference of the litigants of this country. We face a lot of potential challenges based on their technology. And of course, in substantial justice, and we even adjudicate, we face a lot of issues. That exactly we thought of having the conferences too, with support of Commonwealth education. We need also to be aware of the impact that is happening on account of the super norms being being come to a domestic level and domestic issues having a ramification of international ramification. Be that may be, the conference, I'm sure that will help for a further deliberations and the transformation of Indian judiciary. Well, to talking about the software we developed, the in-house team, it's called Sikkim. The Sikkim is quite a different software for High Court and software for the District Court. And I must thankful to my parent High Court Chief Justice Saman Sen for sending in the technical team and sharing source code for developing a module for the District Court for the Sikkim state. This is a unique software we developed for the High Court with integrated with AI, with the support of AI Adalat. It's quite unique in its features, quite integrated with AI, where you can get summarization of the file and all lost of features is there in this software. So, well, for us to today's discuss is all about deliberate and find out practical solutions which we face in the path of digital transformation. It is a digital transformation to impact on the life of our litigants, impact on the socio-economic life of the citizens. So the discussion, I'm sure, will take to a next level of transformation. With these words, I must conclude, but I must thank Honorable Chief Justice, the Honorable Judges of Supreme Court. I know how quite hard it is for you to travel from Bagdogra here. Some of you reached in the midnight. It's, of course, I have no other option. It's all weather that plays something different here. But anyway, you made it to be here. I'm really overwhelmed with your presence. I'm really remain thankful to you. And it's also homecoming for my former Chief Justice of Sikkim High Court, Maheshwari Sahab. So it is your presence will make a difference in this state. And I must also thank Honorable Chief Minister and the government of Sikkim for all kind of support. I come from God's own country, where every file will move with the initial no finally being accepted as an approval. But I find that Sikkimists do not know the no, and there is no in their dictionary. So everything comes with the supports. So I see the difference between God's own countries and God's blessed country. Thank you, one and all. Jai Hind.
Thank you, Lordship, for your illuminating presidential address. I now have the honor of requesting respected R. Venkataramani, Sir, Learned Attorney General of India, to kindly deliver the felicitation address.
When Kerala comes to Sikkim, you can see the Midas touch. And Chief Justice Mushtaq has made this wonderful congregation possible with the Honorable Chief Justice of India, Honorable Judges from Supreme Court, and the higher echelons of the Indian judiciary here. I'm least competent to talk about technology and law in the primary sense. But as they took over this office, some important concerns began to preoccupy my mind. We've been talking about access to justice from a very primordial point of view, something like a Stone Age discussion on access to justice, the physical access, and expanding the access. But today, access to justice means all those tools and instrumentalities which will make not only physical access, but a real substantive access. And what do we mean by that? And why do you have conclaves like this? All of you are here much more informed with your being holding positions as judges of the high courts and with your long experience on how to transform from within the judicial institution into a participating, deliberating institution in the development of the nation. I don't think we could look at courts any longer as a mere dispute resolution mechanisms or institutions. Ever since I remember in 1985, when an English jurist wrote a book on the politics of judiciary, and recently when Robertson writes about the judges as political theorists, and why do we talk about them in the context of judicial education and judicial transformation? I think everything is so connected. In the connection, I find that if governance has to become more responsible, I think it can become more responsible only if there are greater persuasion from within the judicial institution to bring to the notice of the governance institution that where they need to take not only one extra mile and as many miles as needed. And that can happen not only again in the context of making more and more institutions, but I think more and more involvement in terms of finance, in terms of creating institutions where, for instance, we've been talking about the National Informatics Center, as something relevant in the early ages of our technology and law. But I begin to think that it is no longer a mere National Informatics Center, but we need a National Judicial Technology Center, a National Judicial Technology Center. I remember way back in 1992, when Professor Menon inaugurated the National Judicial Academy in Bhopal, we were talking about what is the meaning of training of judges, something very not very what called compatible with judicial holding judicial position. But over a period of time, across the globe, we find as the International Institution for Judicial Training has taken shape, with as many as 123 members being members of this institution. Every country, you look at every country, particularly the Asian countries, the need for judicial education, not from mere knowledge and information, but from a larger fundamental transformation of how to make judicial institutions more and more closer to every justice needs of a community. And that's why we're going to talk about the technology as a collaborator and as a liberator. I think, as I said, judicial education is now intrinsically connected to access to justice. But then how do we transform this access to justice principle from the point of view of technology? Both the learned advocate general and Janice Roper earlier talked about the concerns on the technology development as well as those drawbacks which probably may hit at some point of time. We all keep reading about it every day. And but then as technology grows into our life, so deeply into our life, we can no longer unentangle us from technology. So also when we talk about institutional justice and entanglement of technology, it is not from a negative point of view. So therefore, I think it's important that conclaves like this, when the higher echelons of judiciary congregate, is going to be a great persuasion for the Indian government and state government to think anew and what technology can do, at what institutional transformation must necessarily happen. I have a few other thoughts on this, but I think in the course of tomorrow's deliberations, I'll share with them, because as we move closer and greater involvement of the justice system into policy transformation systems, because virtually every dispute that comes to the courts today has some connection or the other, has some involvement or the other with policy transformation. And policy transformation, if at all they have to happen for the development of a nation, we have too many issues, too many challenges, which cannot be merely unraveled by a technology. But a lot of connection between technology and how institutions function. So within the institutions, it's not making access just at the technological level, but how we best technology itself transformed. Therefore, the transformation of technology is important. So last week, The finance minister talking, addressing the banks about something happening as to about the disruption in what's called a new development in the banking system disruptions. Right, something very disturbing. So the same thing can happen when you have involved technology in the judicial, delivery system. So we need to have. That's why I think it's important for us not to borrow technology, but to create technology. Not to merely borrow technology from elsewhere, but India can become a technology creation center. I think conclaves like this are a great call that India should become a technology creation center. We need not. For instance, when you talk about the intermediaries in the context of the responsibilities and liabilities, too many resistance are happening. Of how to therefore make the tech giants conform to justice system within our country. And if we can give a lead, I'm sure that the rest of the world will follow. I'm not talking from the point of view of hegemony, but I think the kind of experience we had during COVID and post-COVID, you look at the delivery system across the world, I find India scores fairly high. One of my recent visits to Brazil, and when I was called to talk about what's happening in India and the technology development, and I found a small country like Brazil was competing with India. And therefore, this competition is, of course, important. But in the context of competition, I think the kind of experience we have in regard to the culture factors, in regard to the historical factors we have, in regard to the diversity of India, all those factors put together, I think are going to be a great challenge. And it's for these challenges, I suppose, great inventions and discoveries are necessary to happen. I therefore am happy to be here today, and I didn't want to take a longer time. But one of my concerns again is that as Attorney General, I think this office is no longer a mere defending India or the government of India or any other authority before the courts. It is a transformation of the institution. Therefore, this office or any other office which is a correlation or a mediation between government and the judiciary must transform itself. And I'm going to learn from this conclave, and the transformation will become important where we no longer say, well, remain as view spectators, but has become grand mediators. How people like us, institutions like us, can become grand mediators. It's also going to be a great, piece of not only transformation, but something which will fundamentally transform people's perception about justice delivery. And finally, the court management system is not to be seen as a physical management subject. It must become a justice delivery management system. Once we have different expressions and ideas, I think the creative element also undergoes changes. So it's therefore important to change or begin to use new ideas and new words and new expressions that will germinate a lot of thinking process in our mind. And I am so happy to be here today. And certainly, in the course of today and tomorrow, I am here to come as a learner. And the Chief Justice of India here, I'm sure the great initiative that will happen in every High Court and down to the Tehsil level. Maybe 1983, 84, when we talk about Gram Nyayalayas, we talked about the physical Gram Nyayalayas. What can't you think about some of us understanding of what Nyayalayas can be? And that's where technology comes in. We'll certainly talk about deepfake. We'll certainly talk about other kind of disruptions, but I think they're all by the sidelines. We have the capacity, competence, the intelligence, and the genius to what's an India product in technology management of judiciary. That's what you're looking for. The conclave, I wish well. Thank you so much.
We are grateful, sir, for your enlightening felicitation address. With due regard, may I humbly request Honorable Mr. Justice Roni James Govindan, Chief Justice, Supreme Court of Seychelles, to kindly deliver the special address.
My Lord, the Chief Justice of the Supreme Court of India, Honorable Chief Minister of the State of Sikkim, Honorable Chief Justice of the State of Sikkim, Honorable Judicial Officers, ladies and gentlemen, good morning, good afternoon. It is a profound honor for me to stand before you in the breathtaking city of Bangkok. I bring warm regards from the Republic of Seychelles and a heartfelt appreciation for the opportunity to address this distinguished gathering. Over the next 2 days, we will engage with a subject that is no longer a projection of the future, but a defining future of our present: judicial education in the digital age. When courts around the world pivoted rapidly to virtual modes of operation, they did so under duress, in response to an unprecedented global crisis. That rapid development has revealed both the extraordinary potential of digital technologies to expand access to justice and a series of enduring challenges that we must confront deliberately if the promise of digital justice is to be realized after all. Let me begin by identifying the principal challenges we face in virtual courts management. First, the digital divide. Access remains uneven. Many litigants, particularly in marginalized and rural communities, lack reliable internet connections, suitable devices, or the digital literacy necessary to participate effectively is not present. This is not merely a logistical problem. It is a challenge to the fundamental fairness and equality of our justice systems. Secondly, cybersecurity and data protection. Court process sensitive personal and legal information. The migration of case files, hearing recordings, and judicial communications to digital platforms increases the risk of unauthorized access, data breaches, and evidentiary tampering. Robust technical safeguard and clear procedural rules are therefore essential. Thirdly, procedural integrity and evidentiary standards. Ensuring the authenticity and continuity of digital evidence, preserving the chain of custody, and adapting rules of procedure to virtual settings are complex tasks that require careful calibration. Fourthly, maintaining dignity, decorum, and the human element of adjudication. The solemnity of courtroom proceedings, the presence of the bench, the parties, counsel, and the community conveys legitimacy. In virtual environments, we must find ways to preserve respect for judicial processes, ensure effective oral advocacy, and protect the dignity of all participants. Lastly, capacity and training. Judicial officers, court staffs, and lawyers require bespoke training to operate digital platforms confidently, to assess digital evidence, and to manage remote hearing effectively. Training needs to be ongoing and adapted to technological advances. These challenges, however, have led to a wide range of practical and replicable best practices. Across the Commonwealth, courts and judicial training institutions have piloted and adopted measures that we can learn from and scale to our own sizes. These includes: 1. Standardized digital filing and case management systems. Plain interoperable filing protocols reduces friction for litigants and lawyers. Where possible, open standards that enable data portability and interoperability across jurisdictions needs to be increased in terms of its resilience. Secondly, secure end-to-end encrypted hearing platforms combined with multi-factor authentication for participants. Security must be integrated with usability, strong protections that are nevertheless accessible to non-technical users. Also, hybrid hearing models. Not every matter requires physical presence. Triaging of cases according to complexity, issues of credibility, and the need for oral testimony allows courts to deploy in-person resources where they matter most, while resolving suitable matters remotely. Also, comprehensive digital literacy programs. Training for judges and court staffs and lawyers should focus not only on tool operation, but on adapting courtroom management techniques to virtual formats, ensuring procedural fairness, and recognizing forms of digital misconducts or tampering. Lastly, also, there has been clear procedural guidelines and rules of practices for virtual proceedings, published protocols that address service, evidence submissions, confidentiality, and the recording of hearings, build predictability and trust in the system. This brings me to our second focus, designing cooperative judicial education across the Commonwealth. We are united by shared legal traditions, but marked by vast differences in scale, resources, and infrastructure. Creating an education strategy that resonates in large jurisdictions, such as in India, and a small island developing states, such as Seychelles, requires creativity and humility. I propose the following principles for Commonwealth cooperation in judicial educations, notwithstanding the size and the development states of our jurisdictions. 1. Modularity. Design curricula as modular building blocks that jurisdiction can adopt or adapt according to their specific needs and capacities. Modules should be short, focused, and capable of being delivered synchronously or asynchronously. Secondly, scalability. Use cloud-based learning platforms and low bandwidth content options such as audio, text, transcripts, and compressed videos so that smaller or bandwidth constrained jurisdictions can participate fully. Thirdly, share digital repositories. Establish secure central index repositories for best practices, model judgments, training materials, and interactive simulations. These repositories should be searchable, multilingual where it's feasible, and governed by clear standards for quality and ethical use. Fourthly, peer-to-peer and practitioner-led learning. Judges learn effectively from judges. Facilities across border mentorships, virtual bench exchanges, and problem-based workshops that allow judicial officers to discuss real-world dilemma and solutions. Also, we can leverage artificial intelligence judiciously. An AI can support legal research, translate materials, adapt learning path to individual needs, and assist in administrative triage. But its adoption must be accompanied by critical training on its limitation, biases, and ethical implications. Lastly, I propose sustainable partnerships. Organizations such as the Commonwealth Legal Association, Education Association, can act as conveners and custodians of these initiatives, coordinating funding, ensuring quality, and encouraging shared standard. Implementation will require governance frameworks that respect judicial independence, protect confidentiality, and support local ownership. It will also require measurement, regular evaluation of training outcomes, technology performance, and users' satisfaction. Data-driven refinement will allow initiatives to evolve and remain constantly relevant. In closing, the digital age does not diminish human core of justice. It amplifies it. It amplifies our obligations to ensure that legal systems remain accessible, fair, and comprehensible. Judicial education must evolve from periodic workshop to continuous adaptive system of learning that equip judges and court staff with both technical skills and a renewed commitment to values that underpin our common law traditions. Let this conference be a laboratory of ideas and forge of partnerships. Let us leave Sikkim with practical commitments, shared modules, pilot exchanges, and a roadmap for interoperable repositories. By working together across the Commonwealth, we can build a resilient, inclusive judicial education architecture that ensures justice is not only delivered, but also perceived to be delivered, whether in physical courtrooms or across a digital screen. Thank you.
Thank you, Lordship, for your engaging special address. May I most respectfully request Honorable Mr. Justice J.K. Maheshwari, Judge, Supreme Court of India, to kindly deliver the keynote address.
Good afternoon. Honorable the Chief Justice of India, distinguished brother Justice Suryakant, Honorable the Chief Minister of the State of Sikkim, Mr. P.S. Tamang Gole, Mr. Justice Ronnie James Govindan, Honorable the Chief Justice, Supreme Court of Seychelles, brother judges of Supreme Court, R. Venkatramani, Attorney General of India, Chief Justices of various High Courts, brother Muhammad Mustaq, Sister Justice Meenakshi Madan Roy, brother Bhaskar Raj Pradhan, Honorable Judges of various High Courts, Mr. Baswa Prabhu Patil, Advocate General of the State of Sikkim, Mr. Tasi Aplin Barfungta, President, Bar Association of Sikkim, Dr. Doma T. Bhutia, President, High Court Bar Association, other judicial officers present, administrative officers present here, colleagues from Commonwealth countries, respected officers came across the country, members of the bar, dear student, esteemed, gracious ladies and gentlemen. It's my pleasure to be here in Gangtok. Resting in the leap of the magnificent Kanchenjunga peak, I must admit that it is a much needed respite from the Delhi heat and polluted air. For me, this is more than just a formal occasion. Having had the distinct honor of serving as a Chief Justice of Sikkim High Court, I return today with a sense of familiarity and gratitude. Sikkim has always had a unique way of combining simplicity and efficiency. And perhaps that is why it is a fitting venue for a conversation on the future of justice based on technology. It is also heartening to see our friends from Seychelles and other Commonwealth nations. Your presence reminded us, while our geographic may be differ, the goal of delivering justice in the digital age is truly a shared purpose. Whether in Indian Ocean or Himalayas, we are all searching for the perfect balance between efficiency of the machine and the empathy of the judges. There is a timeless idea of Bhagavad Gita, Karmanye Vadikarastu Ma Phaleshu Kadachana. This is not merely a philosophy. You have a right to action alone, not its fruits. It is a reminder of institutional duty. It tells us that our role is not complacent with outcomes, but to continuously strive to improve the process. Though with justice is delivered, we must know how and what manner we have to improve day by day. If one looks at the broad ideas of this conclave, it is not about technology in isolation, nor is it about education in abstraction. It is about the reimagining how we deliver and how we learn justice in a rapidly changing world. Today, the question before us is no longer whether technology will enter in the courtroom. It already has. The real question is how do we ensure that technology serves justice rather than redefining it on its own terms. Take something as a fundamental, like a filing of a case. For decades, the act of approaching a court began with a physical file, a registry counter, and a series of procedural steps that are often understood only by a few. Today, we speak e filing, digital security, scrutiny, and automated workflow. But we must remind ourselves that this transition is not merely about replacing paper with screens. It is about redesigning the experiences of justice. If a litigant or a young lawyer finds the digital system more confusing than the physical one, then we have no simplified access. We have only shifted the complexities. Similarly, when we speak the process of reforms, we must be careful not to fall into the common trap of digitizing inefficiency. A system that required duplication, manual register, multiple layers of the verification cannot become efficient simply because it is now electronic. True transformation lies in re-engineering processes where information flows seamlessly, data is captured once and used intelligently, and the system anticipates needs rather than reacts to them. In that sense, technology forces us to ask deeper institutional questions. Why do we do things the way we do? Can we do them better? At the same time, there is no doubt that technology offers tools that were once unimaginable. We are now discussing the use of artificial intelligence for case management, research, and document handling. We are exploring blockchain for ensuring integrity of records. These are not abstract concepts, but respond to a very real concern: delay, duplication, and lack of transparency. But here, I would sound a note of caution. Technology can assist decision making, it cannot replace judgment making. A machine may analyze patterns, but it cannot understand human suffering. It may process data, but it cannot exercise discretion. The essence of the judgment lies in navigating the gray areas of the life and law, which remains a deeply human function. Here, I am reminded of the Martin Luther King's words: the arc of the moral universe is long, but it bends towards justice. Technology may accelerate that arc, but it is our responsibility to ensure that it continues to bend the right directions. In order to achieve all these lofty goals and implement them successfully in our path of justice, it is without doubt that we must focus on the respect of training, discussion, and learning. The judicial system is evolving. Our method of learning must evolve with it. Judicial education can no longer remain confined to lectures and texts. It must become interactive, experiential, and adaptive. The judges today are required not only to interpret the law, but also to manage digital systems, understand data, engage with technology, and yet remain anchored in constitutional values. Learning, therefore, must be continuous and collaborative, which is an example of this Sikkim conclave. In this context, the presence of delegates from the Commonwealth jurisdiction enriches the dialogue immensely. When we hear experiences from countries like Seychelles and Sri Lanka, we realize that while our legal system may differ, our challenges often converge. Issues such as virtual court management, digital infrastructure gaps, and ethic concerns in the use of technology are not unique to any one country, but shared concern of modern judiciaries. One of the most significant shifts we have witnessed in recent years is the move towards virtual and hybrid courts. What begins as a response to an unprecedented global crisis has now become a permanent feature of our system. Virtual hearings have improved access, reduced cost, and introduced flexibility. At the same time, they have raised important questions that go to heart of procedural justice about the fairness, digital divide, privacy and confidentiality, and maintaining judicial decorum in virtual space. And then there is a question of access. Technology is often described as a great equalizer, but it can also become a barrier if not implemented thoughtfully. A litigant in a remote area, a person unfamiliar with a digital tool, or someone without reliable connectivity, how do we ensure that they are not left behind in this transition? We have to discuss, we have to provide all these accesses. Justice must not only be done, but it must seem to be done. It's a known maxim. How it can be, that would be by our concerted efforts. The another conversation that rightly relevant today is globalization of law and judicial thinking, for which we are here today. The disputes are no longer confined within borders. Issues of commerce, environment, cybercrime, and human rights transcend jurisdictions. This requires judges to be aware of international developments, to engage in competitive reasonings, and to participate in a broader judicial dialogues. At the same time, we must harmonize and remain rooted in our constitutional identity. The challenge is to harmonize the global with local, to learn from others without losing our own context. Before I conclude, I would like to return briefly to Sikkim, which has now been declared as a paperless judiciary. In the long arc of judicial history, that is a remarkable movement. However, it does not mean that justice has become automatic or that the wisdom of a judge has been replaced by efficiency of a server. What it means is that a barrier has been removed. Those physical papers, distance, registry queues, or files that go missing. That is the correct ambition of technology in justice. Not to replace the human act of judging, but to remove every obstacle that stands between an individual and that act. This, I believe, is the spirit which we must approach every session, resolution, and roadmap that emerges from the conclave. Not what can technology do for courts, but what can technology do for the person who still feels that the courts is not for them. The great jurist Roscoe Pound says the law must be stable and yet it cannot stand still. Judicial education and advancement are how the law walks that tightrope anchored in principle but responsive to the world. These 2 days offers us a unique opportunity not just to deliberate but to reflect, to question, and to commit. Let us use this time to build not only better system but a more responsive, inclusive, and human judicial delivery mechanism. Thank you very much. Jai Hind.
Thank you, Lordship, for your distinguished and enriching keynote address. May I now request the Honorable Chief Minister, Shri Prem Singh Tamang Sir, to kindly deliver the executive address.
Thank you. Honorable Chief Justice of India, Sri Justice Suryakant Ji, Honorable Chief Justice of the Supreme Court of Seychelles, Sri Justice Ronnie James Govindan Ji, Honorable Justice Supreme Court of India and the former Chief Justice of the High Court of Sikkim, Sri Justice Jitendra Kumar Maheshwari Ji, Honorable Judges of the Supreme Court of India who are present here, Honorable Sri Justice Prashan Kumar Mishra Ji, Honorable Sri Justice Ujjal Bhoyan Ji, Honorable Sri Justice Venkata Bhatta Ji, Honorable Sri Justice Sandeep Mehta Ji, Honorable Sri Justice Vijay Bishnoi Ji, Honorable Sri Justice N. Kitoswar Singh Ji, respected Attorney General of India Sri R. Venkata Raman Ji, who is present here, Honorable Chief Justice High Court of Sikkim Sri Justice A. Muhammad Mustaq Ji, Honorable Chief Justice from various high courts of the country who are present here, Honorable Judge High Court of Sikkim, Mrs. Justice Meenakshi Madan Rai Ji, Honorable Judge High Court of Sikkim, Sri Justice Bhaskar Raj Pradhan Ji, all honorable judges from different high courts of the country who are present here, respected Advocate General of Sikkim, Sri Bashava Prabhu S. Patel Ji, who is also here, respected Chief Administrator cum Cabinet Secretary, Government of Sikkim, Sri V.V. Pathak Ji, respected Chief Secretary, Government of Sikkim, Sri R. Telang Ji, respected Director General Police, Sri Akshay Sachdeva Ji, respected Secretary, Law and Parliamentary Affairs, Government of Sikkim, Sri Suras Chetri Ji, esteemed dignitaries and officials from the Government of Sikkim, honorable district judges, esteemed legal luminaries and eminent jurists, advocates, member of the organizing committee, invitees, scholars, students, participants, friends from press and media, ladies and gentlemen. Namaskar and good afternoon to all of you present here. At the outset, I extend my warm greetings to each of you on the auspicious occasion of Buddha Purnima. May this holy occasion inspire us to embrace the values of kindness, humanity, and harmony in our daily lives. May Lord Buddha bless us all with peace, happiness, good health, and spiritual fulfillment, guiding us towards a more compassionate and enlightened world. Today, we also observe International Labor Day. On this momentous occasion, I extend my warmest greetings and convey my sincere appreciation and gratitude to every working section of society for their untiring dedication, hard work, and invaluable contribution to the progress of the nation. The judicial system has played an important role in protecting the working class by ensuring their rights, dignity, and basic safeguard through various laws. Honorable Chief Justice of India and respected dignitaries, we feel proud and honored as Sikkim celebrates the historic milestones of 50 years of statehood, reflecting our rich journey and achievement. During the auspicious moment, the recent visit of the Honorable Prime Minister of India, our country, Sri Narendra Modi ji, to grace the closing ceremony of the 50 years of Sikkim statehood has added great value and importance to this celebration. Today, on this important and blessed moment, it is a great honor, privilege, and happiness for all of us to host this conclave on technology and judicial education. We are truly grateful that such an important event is being held in our state during this special Golden Jubilee years of statehood. We are equally honored by the benign presence of the Honorable Chief Justice of India, Sri Justice Suryakantji, and the Honorable Chief Justice of Supreme Court of Seychelles, Sri Justice Roni James Rabindanji, along with Honorable Judges of Supreme Court of India, Honorable Judge from the Supreme Court of Sri Lanka also here, and Honorable Chief Justice and judges from various High Court across the country. Despite the challenges posed by our difficult terrain and unpredictable weather, your gracious visit reflect your deep regard and strong commitment to our state. We are sincerely thankful for your kind presence, which has focused national attention to Sikkim. This will help in the growth and development of our state in many ways. Similarly, I extend my warmest greetings and heartiest welcome to the respected dignitaries from our country, foreign delegates, and esteemed member of the Commonwealth Judicial Education. I extend immense debt of gratitude to the Honorable Chief Justice of India for selecting Sikkim for this important event and giving us the privilege to host you all. On this momentous occasion, I congratulate and thank the Honorable Chief Justice of the High Court of Sikkim, Sri Justice A. Muhammad Mastakji, for his commendable initiative and exemplary leadership in making this event a grand success. Within just a few months of assuming his esteemed office in Sikkim, in coordination with the Honorable Judges of the High Court of Sikkim, Mrs. Justice Minakshi Madan Raiju, and Sri Justice Bhaskar Rajpadhanju. This reflects a strong commitment to strengthening institutional cooperation and advancing the cause of justice in Sikkim and across the country. Honorable Chief Justice of India and respected dignitaries, today we have galaxy of honorable judges and juries present in this significant occasion. I am sure that your high deliberations here would have a significant impact on resolving the contemporary problem in this challenging world and will go a long way in enriching jurisprudence at both national and international level. The discussion in this conclave is about how technology and the justice delivery system work together. This is a very important and timely topic in this digital era of the 21st century. From my own experience, I believe that change take place for betterment in life, and technology is the main driver of this change in this world. It has also made the pace of change much faster. Today, within a short span, we have reached advanced technologies like artificial intelligence, machine learning, and robotics. All of us are adapting to this rapid change. I am also glad that important topics like artificial intelligence and the use of blockchain in the justice system will be discussed during this conclave. These technologies are bringing major changes and have far-reaching impact. In general, I hope the discussion over the next 2 days will guide us towards building a strong and modern digital judiciary. The combination of law and technology can improve the justice system not only in India but across the Commonwealth. The conclave focuses on using technology in courts and judicial work. Steps like e-filing and digital case management will make the system faster, easier, and more efficient for everyone. These discussions are very important for building a modern and transparent legal system. We must ensure that technology helps everyone and that no one is left behind due to lack of access. I'm happy to be part of this important moment as the Honorable Chief Justice of India will declare Sikkim as paperless judiciary. This will be a historic step for our state, and if I am not wrong, a significant milestone for the nation as a whole. Thus, Sikkim continues to lead through innovation and good governance, and I congratulate the Honorable Chief Justice of Sikkim and the Honorable Judges of the High Court of Sikkim for this significant achievement. The presence of international delegates encourages the sharing of best practices and strengthening global cooperation and learning. Honorable Chief Justice of India and respected dignitaries, Sikkim has always tried to move forward with new ideas. We are improving our judicial system by expanding courts to remote areas with improved infrastructure and strengthening institutions like the Directorate of Prosecutions. We are also confident that the National Law University in Sikkim will become a center of excellence in legal education and research. Similarly, the Sikkim State Legal Services Authority is also doing important work in spreading legal awareness among people. Our government fully supports the efforts of the High Court to strengthen the e-court system. We are not just digitizing but truly transforming our judiciary as India moves towards the vision of Viksit Bharat 2047. A strong and modern judicial system is very important. It will support growth, ensure fairness, and build trust among people and investors. Before I conclude, I express my sincere gratitude to the Honorable Chief Justice of India, Sri Justice Suryakantji, Honorable Chief Justice of Supreme Court of Seychelles, Sri Justice Roni James Govindanji, and all distinguished guests for being here with us. It is a great privilege for Sikkim to host this significant conclave. I wish you all a pleasant and memorable stay in Gantok, nestled in our pristine Himalayan state, renowned for its green, clean, and serene environment. May your time here be comfortable and refreshing, also enriching and truly meaningful. Once again, I thank all of you for coming all the way from different parts of the country and abroad to make this important event successful. Lastly, I sincerely thank the Honorable Chief Justice of India for giving the Government of Sikkim the opportunity to be the part of this important event. My best wishes for the grand success of the conclave. May the atmosphere be pleasant and supportive in every way for its smooth and successful accomplishment. Thank you. Jai Hind, Jai Sikkim.
Thank you, sir, for the inspiring executive address. I now have the deepest honor to invite Honorable Mr. Justice Suryakant, Chief Justice of India, to make the official declaration of Sikkim as the first paperless state judiciary. Lordship, I request you to press the button for the slider placed before you on the table and do us the honors. Thank you, Lordship. I now humbly request Lordship to kindly present the inaugural address.
Shri P.S. Tamang, Honorable Chief Minister of Sikkim, my esteemed colleague and Senior Judge in Supreme Court, Justice J.K. Maheshwari, my other esteemed colleagues from the Supreme Court, Justice Prashant Kumar Mishra, Justice Ujjwal Bhuiyan, Justice S.V.N. Bhatti, Justice Sandeep Mehta, Justice N. Koteshwar Singh, Justice Vijay Bishnoi, Dr. R. Venkat Ramani, Learned Attorney General for India, our distinguished guest, Justice Roni James Govindan, Honorable Chief Justice, Supreme Court of Seychelles, Justice A. Mustaq Mohammed, Honorable Chief Justice of the High Court of Sikkim, various distinguished Chief Justices representing different High Courts, Justice Meenakshi Madan Rai, Justice Pradhan, the judges of the High Court of Sikkim, galaxy of judges representing most of the high courts on pan-India basis, Vice Chairman, E-Committee, Supreme Court of India, Mr. Patil Learned Advocate General, Sikkim, Mr. Tashi Raptan, President of the Bar Association of Sikkim, Dr. Doma T. Bhutia, President of the High Court Bar Association, Secretary General and other officers of the Supreme Court of India, Mr. Raminder Yelang, Chief Secretary Sikkim, Mr. Akshay Sachdeva, Director General of Police, Mr. Vijay Bhushan Pathak, Chief Administrator cum Cabinet Secretary of the State of Sikkim, Learned Registrar General and other officers of the establishment of the Sikkim High Court, very distinguished Vice Chancellors, Dean and other academia, President of the Commonwealth Legal Education Association, district judges and other judicial officers of the state of Sikkim, senior advocates and very distinguished members of the different bar associations of Sikkim, very distinguished ladies and gentlemen, my dear students, friends from media, good afternoon to one and all present here. It has been a real pleasure to listen to so many erudite and eloquent speakers, though most of the issues have been aptly highlighted. I will make my sincere effort to add some new thoughts. Let me begin by saying that there is no better place than Gangtok to organize this conclave on technology and judicial education. I say so because I visualize that under the watchful gaze of Kanchenjunga, ideas can rise as high as the peaks themselves. Sikkim's awe-inspiring natural beauty is more than a mere backdrop. It is a catalyst for inspiration. In this tranquil environment far from meddling crowd of Delhi, the minds find the space to reflect deeply. Nestled in the serene embrace of the Himalayas, Sikkim's snow-capped mountains, verdant valleys and sparkling rivers are a sanctuary where tradition and progress both meet. It is here, I believe, that the pursuit of justice can be envisioned anew. While the natural grandeur of Sikkim is truly mesmeric, it also reflects the difficulties of the terrain itself. The mighty Himalayas, magnificent as they are, make movement slow and uncertain. If you look at the scenario just a decade or so ago, for a Sikkimese litigant seeking justice, distance was not measured in kilometers, but in days of travel across narrow paths and unpredictable weather. The journey to a courtroom was often measured as a test of endurance. Today, that reality is changing, as not only because of robust infrastructure development, but also because technology begins to redraw the map. Where rivers once cut through, valleys and mountains stood as barriers, digital networks now strive to create new pathways. If the ancient Silk Road once connected these regions to distant worlds, the digital highway now connects citizens directly to various judicial fora. It is our aspiration to achieve a scenario where a hearing need not wait upon an arduous journey, and a petition can now travel where a person once had to. The inauguration of this national conclave, therefore, carries a deep symbolic significance. It reminds us that digital reform is not a matter of theory, but a practical necessity for sustaining the rule of law. When we speak of integrating technology into judicial process across the country, we are, in fact, addressing the dismantling of geographical constraints, whether they arise from difficult terrain, financial barriers, or sheer distance. The digital highway thus ensures that access to justice is not limited to the urban centers of the plains, but it also extends equally to a remote hamlet in North Sikkim, the dense landscapes of the Western Ghats, or the distant islands of Andaman and Nicobar. The Indian legal landscape has undergone a fundamental transformation. We have moved away from the era of the paper trail, and I must congratulate to my brother Justice Mustaq, the Chief Justice of Sikkim High Court, for taking this initiative and getting the unique honor to the High Court of Sikkim being the first paperless High Court in the country. So when we have moved away, or we are moving in substantially from this era of the paper trail, where vital records languished in physical storage, as we were seeing in the video clip, to a vibrant now digital ecosystem, the e-courts project has rewritten the relationship between the litigant and the law. What once required physical presence and toilsome inquiry is now available through a simple digital interface. In consonance with this advancement, the National Judicial Data Grid stands as the beating heart of this endeavor, offering a window into the pulse of our judicial performance. It provides data that speaks, revealing systemic health of our institutions in real time. Beyond basic data collection, we have witnessed the advent of intelligence assistance within our chambers. With tools like SUVAS and SUPACE, the judiciary has begun to harness the potential of algorithmic support. These innovations act as force multipliers, aiding in the swift translation of judgments and providing rapid, comprehensive research to bench. They indeed relieve the judge of the mechanical burden of routine inquiry, allowing for a deeper immersion in the complexities of law. This represents an elevation of the craft of judging, where technology handles the clerical to liberate the creative. The true measure of this renaissance, however, lies in its accessibility. The architecture of justice has now more than ever become porous, letting the citizens look inward. When a litigant in the most distant corner of the country can track the progress of a case or view an order without intermediaries, if he can engage counsel from across the country and view proceeding in real time through video conferencing and live proceedings, the power dynamics of the courtroom undergo a healthy calibration. This transparency, to my mind, acts as a powerful disinfectant against delays and inefficiencies. It is a testament to the fact that we are building a system where the process remains visible, predictable, and remarkably lean. Ladies and gentlemen, despite these significant strides, our journey towards a fully digitized institution remains an ongoing one. We have introduced important measures that are already easing judicial processes and assisting stakeholders across the system. Yet, it would be premature to assume that the task is complete. There is still much to be done and much to be achieved. If we are to fully realize the potential of these efforts and ensure that they translate into meaningful access to justice for all, let us take advantage of this unique occasion, and I would like to highlight a few suggestions that might further boost our digital reforms initiatives that we propose to deliberate in this 3 days conference. To begin with, the large-scale digitization achieved in our trial courts through the National Core Case Information Systems must now find a clear and consistent reflection in the higher judiciary through stronger standardization. I say this because while high courts were initially hesitant in adopting this technological foundation, recent developments indicate a clear and more positive shift. The rollout of NCCIS 4.0 for district courts and NCCIS 1.0 for high courts marks a step towards building a more uniform national framework. What makes this system particularly effective is its core and periphery architecture. It enables the high courts to align with a common national standard while still accommodating state-specific requirements, whether in terms of nomenclature, local language needs, or procedural workflows. This balance between uniformity and flexibility is essential if digitization is to work across a judicial system as diverse as ours. This standardization exercise must also be accompanied by an expansion of e-Seva Kendra. These centers must grow beyond being simple access points and develop into effective hubs of digital support. In a country marked by varying levels of literacy, they serve as the crucial link between the complexity of the law and the immediacy of a citizen's need. Strengthening this technical capacity is essential to ensure that the digital divide does not become a new line of exclusion when we are working hard in terms of our constitutional commitment towards principles of inclusivity. At present, there are 48 functioning Kendras in high courts and 2,283 operational units across district courts. This already reflects a strong and widespread infrastructure capable of delivering digital court services at a national scale. The effort now must be to build on this foundation. The aim is to create a system where technology is so intuitive that it recedes into the background, leaving the citizen with a clear and accessible experience of justice. Finally, there is clear scope for the careful infusion and granular application of artificial intelligence at the trial court level. In the context of, for example, say recovery suits, predictive and analytical tools can be deployed at the very threshold of litigation instead of allowing valuable judicial time to be spent at the execution stage on tasks such as verification of assets, tracing encumbrances. These systems can undertake such foundational checks with a degree of speed and accuracy that manual processes often cannot match. By confining the existence of property or flagging conflicting claims at the outset, we can reduce the inflow of vexatious litigation and allow courts to concentrate on the substantive issues in dispute. Similarly, artificial intelligence systems can be deployed to identify patterns in sentencing and bail practices to promote greater consistency and predictability. My colleagues in high courts and Supreme Court will recollect after takeover, I had just flagged an issue of a national judicial policy. that policy was only to bring on certain issues a judicial consistency, and that consistency is needed not only for predictable outcomes but also to ensure a speedy disposal of the matters which should not clog the courts for a long. And it is in this backdrop that I believe that artificial intelligence systems can be quite hopeful. By examining how similar offenses are treated across different jurisdictions, such tools can assist judicial institutions in recognizing variations, addressing unintended disparities, and moving towards a more coherent approach in decision-making process. The sophistication of these tools, however, remains underutilized unless it is matched by a corresponding evaluation in our judicial thinking. This conclave recognizes that adoption of technology is not only about implementation, but also about a necessary shift in legal education. It is no longer sufficient to be well versed in the statutes of the past. The modern judge must also engage with the logic that underpins emerging technologies. Our judicial academia, therefore, must move beyond basic digital literacy. They must encourage a deeper understanding of how artificial intelligence systems operate and how they intersect with long-standing principles such as natural justice. Only then can technology be integrated in a manner that strengthens rather than unsettled the core values of the legal system. This pedagogical shift calls for a curriculum that is both rigorous and forward looking. Judicial education must equip judges with the intellectual tools to examine these technological tools and technology all critically so that the bench remains in control of the system it adopts. At the heart of this educational shift lies the question of ethics. As we integrate automated tools into our daily work, the judge's role as the guardians of human element becomes even more significant. Education must strengthen our ability to identify bias within systems driven by artificial intelligence and to safeguard the integrity of the adjudicatory process against an unintended distortion. We are, in fact, preparing a generation of jurists who see technology as an aid to their commitment to fairness, not a replacement for it. The classrooms becomes the space where this balance is carefully shaped, where technical understanding meets our constitutional values. In doing so, we ensure that our movement into the digital age remains anchored in careful scholarship, in the enduring principles that guide our justice system. The culmination of these efforts finds a fitting stage here in this placid heights of Sikkim. I must take this opportunity to congratulate the Chief Justice, judges, and other stakeholders of Sikkim High Court, particularly the state government led by the Chief Minister, Sri Tamang, for having taken this tectonic step of becoming the High Court as a paperless institution and bringing Sikkim on the national map for such a important and a futuristic conference where the ideas that how the justice delivery system must operate in the coming decades are to be deliberated and a new map is to be evolved. I also extend my warmest wishes for the success of this conclave. May the deliberations over the coming days be as luminous as the sunrise over the peaks of Gangtok, providing us with a roadmap that is both valorous and compassionate. I congratulate every participant for embarking on this vital mission to ensure that the light of justice remains inextinguishable, accessible, and eternally bright. I am again thankful for the organizers for inviting me, giving me this opportunity to share my views and ideas. Thank you very much. Jai Hind, Jai Bharat.
We are honored and remain deeply grateful to your Lordship for your invaluable inaugural address. Thank you. May I now humbly request Honorable Mrs. Justice Meenakshi Madan Rai, Judge High Court of Sikkim, to present the concluding remarks before we begin the technical sessions.
The last man, the last woman standing between this illustrious gathering and lunch. So I'll make it a quick wrap up. Honorable the Chief Justice of India, Honorable Chief Minister of Sikkim, Honorable the Chief Justice of the Republic of Seychelles, Honorable Supreme Court Judges, Chief Secretary, the Attorney General of India, the Advocate General for the State of Sikkim, esteemed members of the Commonwealth Legal Education Association, the Director General of Police, academicians, judges of the District Judiciary, advocates, all other esteemed dignitaries, ladies and gentlemen, students, press and media, both print and electronic. We from the Sikkim High Court are indeed grateful to this illustrious gathering for overcoming the travails of distant travel and the unending urgency of impending indispensable work and being present here to discuss topics of national relevance. As we now close the inaugural session, it is evident that this conclave, comprising of intellectuals and technological experts from across the country, and our guests from Sri Lanka, the island nation of Seychelles, and the far shores of the United Kingdom, will not merely discuss technology as a matter of administrative convenience, but will engage in a far deeper question: how the justice delivery system of our nation will continue to uphold constitutional values while adapting to the demands of a rapidly changing age. The constitutional promise of justice today requires not only fairness and independence, but also accessibility, efficiency, transparency, and expeditious delivery. For a country of India's size, diversity, and complexity, the challenge of access to justice, though real, is unique. Vast distances, varying levels of infrastructure, linguistic diversity, cultural differences, and economic limitations often stand between the citizen and effective legal redress. Technology offers practical means to bridge many of these divides. A litigant should not be denied justice merely because of geography, lack of resources, or procedural complexity. Systems that simplify filing, enable digital access to information, facilitate remote appearances where appropriate, and improve case management are therefore instruments of inclusion. The deliberations that will ensue in the course of 2 days will traverse several themes of enduring importance, including the emerging possibilities presented by artificial intelligence, as also its responsible use. It is also an endeavor to create a platform for Commonwealth judicial educators to exchange best practices in judicial education. Yet, while we welcome innovation, we must do so with measured wisdom. Courts are not factories of output, and justice cannot be reduced to metrics alone. Judicial function rests upon independence of mind, careful reasoning, appreciation of facts, fidelity to law, and sensitivity to human consequences. And it is here that we must realize that technology can aid education, but it cannot replace human intervention in the preparation of judgments. No algorithm can substitute conscience. Technological advancement should not erode confidentiality or due process. It is therefore necessary that technology in the judicial sphere remain principled and designed to assist. The conclave will also demonstrate the values and benefits of dialogues across institutions. Lasting reform cannot be achieved in silos. It requires cooperation among courts, governments, judicial academies, members of the bar, administrators, and technical experts to make it sustainable. It is especially fitting that such a conference has been convened in Sikkim under the able guidance and leadership of Honorable Mr. Justice A. Muhammad Mushtaq, who took over the reins of the Chief Justice of this High Court only as recently as the 4th of January 2026. As an expert in the field of technology, he has quickly guided the entire computer section of the High Court into mission mode drive, including arranging this program. This state, though modest in territorial extent, has always shown that vision is never measured by geography, that an important national conversation on the future of justice should take place in these serene surroundings, which bears the hallmark of good governance and dedication to the people of state, is both apt and encouraging. The true measure of the success of this conclave, however, will not lie in the quality of speeches or the breadth of discussion, but in what follows hereafter. If the ordinary citizens find the courts more accessible and proceedings more efficient, the records more transparent, and outcomes more timely, then the aspirations of this conclave will surely stand fulfilled. I thank the Honorable Chief Justice of India once again for having taken time off, bearing with inclement weather, to be with us to inaugurate the function and put it down in the annals of Sikkim history. I express my heartfelt gratitude also to the Honorable Chief Minister of Sikkim, who has given the judiciary his unrelenting and unstinting support, the Honorable Chief Justice of the High Court of Sikkim for his leadership, and to all our esteemed guests and dignitaries who are present here. I hope the conclave is going to be enlightening and you will enjoy the 2 days of stay in the state of Sikkim. Thank you.
Thank you, Ladyship, for your insightful concluding remarks. Before we break for lunch, a gentle update to the esteemed delegates that the working sessions will commence at 2:30 p.m. at the present venue, and the second conference on Commonwealth Judicial Educators in the Digital Age shall be held at Samman Bhavan simultaneously, as per the schedule provided to you. To the Honorable Lordships and esteemed delegates, the organizers will also assist in the movement. I now humbly request all present here to rise for the national anthem.
जनगणमन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंह गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उज्जल जलधि तरंगा तब शुभ नामे जागे तब शुभ आशीष मांगे गाहे कर जय गाथा जन गण मंगल जय हे भारत भाग्य विधाता जय 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 Jai 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 Jai.
The organizers now request to escort all the distinguished guests for lunch. Thank you.